Hey jerks, welcome back after a while last night. I'm a little self-conscious. I'm worried about moving my hair after Auntie Deb did his thing last night. That was wild. Just a really good time last night. I want to thank LTL Media. I want to thank Nurse Kim. I want to thank Boozy Beauty, and I want to thank Auntie Deb, and of course the cousin Kelly Reed for being on the show last night. That was just an amazing, fun show last night. If you didn't get to check it out, definitely do check in on that. And I want to thank everyone who was watching and donating. We raised over $5,000 last night for the Karen Reed Defense Fund. I was sending out all the stickers today. A lot of stickers went out. You guys are amazing, and quite a bit of donations for Turtle Boy too, Aiden Carney. Very happy about last night's show. It was so much fun. Thank you, everybody who like if you even just watched it last night. If you had fun, if you laughed, and especially if you made a donation. I just want to thank you all. I want to thank our moderators, MJ, Sarah, and Chuck, and Hara. Happy birthday to her. I want to thank Stephanie, who designed are the 3M stickers that we've been giving away right now. Thank you so much to her. Jen O, and as well as Scott McGinnis. We have the best moderators around. We have a great guest tonight. I'm really looking forward to this tonight. We have her back on the show. This is going to be our first one-on-one interview. In the past, she's been on the Young Jerks as a panelist. She's a legal commentator. She has her own YouTube channel that many of us watch. It's very popular. She covers a variety of cases. I was just checking out some of her other coverage. She covers the Richard Allen stuff very heavily, but she's also been covering the Karen Reed trial and retrial. And that's what I have her hopefully here to talk about tonight. She could talk about some of those other cases too. If you have questions on any of it, definitely hit us up in the chat. I'm really excited to have her back with the Young Jerks. Welcome back, attorney Andrea Burkhart.
Thanks, Mike.
Thank you for being here. How are you doing
Oh,
tonight?
it's a pleasure. I'm doing fantastic. It's great to be here. Thank you so much for having me.
Thank you. And you have been covering some other cases. Richard Allen, I see that you get some like heat on that one, haven't you? You've gotten like I think the judge has even been calling you out, hasn't she?
Oh, Nancy Grace did.
Oh, Nancy
Well,
Grace, that's who
in
it was.
fairness, I
Yeah.
called Nancy Grace out first, but oh yeah, it's I'm just discovering it seems to kind of come with the territory with some of these cases, and just having a voice that, for whatever reason, lots of people out there seem to want to listen to it. And so you garner a lot of dissent from folks who don't necessarily reach the same conclusions that you do. In and of itself, disagreement is totally fine. I'm a lawyer, for heaven's sake. It's like my bread and butter. We kind of love a good disagreement. It's just unfortunate that, in a lot of these contexts, you're dealing with criticisms that are not really in good faith, or debates that are not really in good faith. It's just kind of boring and pointless and valueless name calling and stuff like that. So you do have to kind of wonder a little bit about what some of the motivations for some of that is. But, trolls are going to troll.
We've been questioning that forever here on the Karen Reed defense. A lot of us, YouTubers and commentators, because we've gotten so many trolls and haters. It is wild. Is it wilder, do you think, with Karen Reed or Richard Allen, or both like equally just kind of toxic?
Well, it's just different. It's very different. I think part of the issue with Karen Reed, that's a little bit different than Richard Allen, is that just frankly they're really dumb. A lot of the criticism, it's just dumb. It can't address the merits of the issue, and so it's just a lot of like name calling and very sort of petty juvenile stuff, and the gaslighting. The gaslighting is always a tell. You can't win something on the merits when you have to ignore the reality of the situation, and you have to try to insist that the reality is something other than what people can see for their with their own eyes. So I started to encounter that a lot during the the first Karen Reed trial, when we're literally sitting here watching the trial. Okay, I can see with my own eyes what's happening, and you just you get all these reactions and comments and stuff that just aren't on this planet. They are not watching the same thing that the rest of us were watching. And so I kind of took the opportunity to invite my chat to consider itself like a gaslight proof zone. Like we're not a gaslightable bunch. Okay. I'm the kind of person that isn't afraid to have an opinion and a perspective and stuff. Certainly doesn't mean that new information isn't going to shift me off it, but I'm not gonna not see what's in front of my eyes just because somebody doesn't want me to. So that's really what stands out to me about the Karen Reed, is just the total lack of good faith that there really seems to be in so much of this trolling and so much of this insistence that she did it. I mean, just the kind of classic example, you say anything at all out there about the Karen Reed case and about what's going on, you'll have a gazillion reactions. Karen Reed killed John. And it's like, well, that's the whole issue for the jury to decide. And there was like 6 weeks of trial, for us to evaluate that and everything. So yeah, just not a very intellectually sophisticated type of operation.
It's kind of a joke at times. Michael Proctor today. It's funny because it's funny how they think they're going to sway us with insults. Like they called me the young jelly, and now we got the sticker, the young jelly,
Nice.
which people love. We got t-shirts. Like
pretty dope.
It's like, thank you. Like you gave me the best nickname ever that people love. It's so funny. Like some of their insults turn out to be, I get excited. I do now. Like at first, maybe a little bothered me at first, but now if they're not coming after me, I'm like, we haven't been doing anything good lately, apparently. Like they're not. So it's fun. It is fun in the end. So with Karen Reed right now, there's been so much going on with all of these, filings, basically. It's just been like so much paperwork from both sides. What stands out to you at this point? You've reviewed all of them.
Oh, man.
Which I haven't had time to see them all, but what do you think about them? Well, which ones stand out to you?
We're obviously in the big flurry. The run up to April 1st looks pretty clear. Like that's when we're going to get going. There's not going to be any kind of last minute motions to continue or anything like that. So everybody is gearing down for that to happen. So yeah, by my count, we had, and I could have missed some, please don't take me as gospel, but I'm pretty sure we had about 15 motions in limine from each side. So 30 total motions in limine. We had the motion to reconsider Mr. Crosby as the expert witness. We just got witness lists, I think, from the Commonwealth posted today. And that's on top of, everything that's happened over just the last couple of weeks, the issues with Bettero being denied his pro hac vice status, and just all of this other stuff that's kind of going on at the last minute. So the Bettero issue is definitely one that has stood out to me for a variety of reasons, but the main one being that I'm an appellate lawyer. I focus on if there's a conviction and things are going to go up to a reviewing court, what's that going to look like? What are the types of issues that tend to be strong in that context? What are the types of issues that tend to be weak in that context? And the Mark Bettero motion, that order, it's such a strong appellate issue from a defense standpoint, because it falls within this category, this very rare category of types of appellate errors that are called structural errors. You basically have very, very few situations where the court doesn't look at an error as a no harm, no foul type of situation. So they always want to know. The rule is kind of, you're not entitled to a perfect trial. You're just entitled to one that's like fair enough. And so unless this really had a significant impact on how things went, even if it was wrong, we're not necessarily going to mess with it. And so for most errors, you're dealing with a harmless error type of framework where you have to look at like, what's the total picture and how did this particular thing fit into it? And that's what can make things like evidentiary rulings things that affect the evidence that come in and so forth, that can make them a little bit hard to work with, because you just take like one thing in isolation in a 6-week trial, and it's kind of hard to show like, well, this is the dispositive thing that would have, acquitted her had the jury only heard about that. Structural errors are totally different. You don't have to show any impact on the trial at all, because it's considered to be so integral to the function of the trial, the process of the trial, that without that, you just assume that things haven't been fair. So there are very, very few structural trials structural errors that you have in the appellate world. Well, denial of the Sixth Amendment right to counsel of choice is one of those. And so I went through and I looked at some of this. There's some pretty favorable case law on her side with respect to, pro hac vice admission, fairly recent decision that came down from the U.S. Supreme Court. And I say fairly recent, I mean within the last couple decades, I think around 2010 or so. Dealing with a, real similar situation, a guy trying to get pro hac vice admission. The court basically misapplied the rules for whether that should have been allowed or not. And so it was an abuse of discretion in applying those rules. And because that error implicated that person's right to be represented by the attorney that they wanted, it's a structural error. It's automatic reversal. It doesn't even matter what happened in the trial or how good the evidence was or anything like that. So that was a big order. That was a big order to come down. It was a very high risk decision by Judge Cannoni. I kind of wonder if she's really aware of what a high risk decision that was. Because as I read the order, she really didn't do a very good job of insulating it against review. She has this kind of tendency, like she did in some of these other orders, like Alessi calls her out for it in this motion to reconsider Mr. Crosby. He's like, you just say in this conclusory way, well, this thing is established. But with appellate review of a court's ruling, they're looking at not just what did you decide and what is the law. They're looking at what's the factual basis, what record did you have, and what analysis did you engage in to reach this conclusion. And so she has this kind of bad habit of not really getting into that. And in this particular case, I think that's especially damaging, because she's just kind of saying, well, there's this unwaivable conflict of interest. Well, we don't have any record of what the potential conflict of interest is, what exactly it is factually that she thinks could go wrong. These are not co-defendants. This is a situation, from what I can see, it has to do with Mr. Bettero's, he's representing Turtle Boy, in his witness intimidation suit. The Commonwealth is trying to get the discovery from Turtle Boy's case, like incorporated, like to be able to use it in Karen Reed's case. And I think specifically what they're looking for is the text messages between them, as the Commonwealth, is wanting to show they're trying to intimidate witnesses and stuff like that. And Karen Reed is like complicit in this, and that makes it's like proof of some kind of consciousness of guilt. So as best as I can tell from what I know from outside of the record, that's kind of what this is based on. But there's nothing in that situation in and of itself that tells me this is an unwaivable conflict. The rules themselves contemplate that most conflicts can be waived. And frankly, this sounds like a situation to me where their interests are in alignment. Like if Turtle Boy is called as a witness and he's put on the stand and he's asked about these text messages with Karen Reed, they both have the same interest in establishing nobody was intending any witness intimidation here. That's not what this was about. So
they both signed affidavits too. Like they both said that we understand and we're waiving any rights here. We both want Bettero, which is, to me, it was wild that she didn't even call a hearing about it. Like, she just decided that, like, she had Hank Brennan not do an affidavit. He just basically said he wasn't going to oppose it, and then he opposed it without even
Mhm.
letting the, attorneys know what his opposition was going to be. She has them submit something in writing, but then she just decides, which to me, that's wild. Like, I feel like she should at least had a hearing. Is that what she should have done, do you think?
Yeah.
Like, more fleshed
Well,
out?
for her own protection, if nothing else, for her own protection in this ruling, to be able to establish that basis of, okay, well, what exactly is the problem here? Because if a court of appeals is looking back on this, they're not reading the newspaper, they're not looking at Twitter, they're not looking into the other cases. They're just getting what was filed in that court and anything that's been said in the court hearings and in the transcripts. And so in terms of what's actually been filed in that court, the record of she wanted Mr. Betterow and why shouldn't Mr. Betterow be allowed? It's really, really sparse. And so if she'd had a hearing, she could have fleshed out some of this stuff. Like, well, okay, so what's the nature of this relationship, and what are the potential problems that could come up? It's just maybe there's something that's going on that I don't even know about. I know something that somebody has mentioned is that there's this other side issue kind of going on that I don't know a whole lot about, but I've just kind of seen in passing, which is that Michael Morrissey got caught using like a burner email to have
Cheesy, but listen to the email. Cheesy Banana was the email address. Can you believe that? Cheesy Banana.
I gotta look that up and get caught up on some of that. But yeah, so I guess he's using a burner email to communicate ex parte with judges, which is like a huge no. It's major ethical violation on everybody's part. And so Mr. Betterow raised that with Turtle Boy's case, got an order to basically have somebody go in and review Mr. Morrissey's emails to see if he was communicating with the judge in that case. And so my understanding is that there's like a similar motion that Mr. Yannetti filed in this case to look for any emails with Judge Cannone. So, I mean, is that part of it? Does that play in because that like originated from the Turtle Boy case? I really don't know. Like, it maybe, but we don't have a record to establish what's the problem here because she never had a hearing. So, without her being able to substantiate that ruling in some kind of fact, some kind of evidence that you can rely on to say this is what happened and this is what the situation is, it's hard for that to stand up on appeal because your decision is sort of arbitrary if you're basing it on just things that you're imagining that you can't substantiate. It's not your job as a judge to think about sort of imagine the reality. You're supposed to take testimony, take evidence, and decide based on that. Maybe you weigh it, and some of it's more credible than others, and you make findings of fact and so forth. But you basically get a record of what the situation is, and you base your decision on that. So the fact that she hasn't done that in and of itself, it doesn't look good from an abuse of discretion standpoint.
Me crazy. We love Betterow here. He was on the show so many times. He's a friend of ours. I haven't asked him about any of this stuff.
He's a fantastic lawyer.
Yeah.
Fantastic lawyer.
And he's very ethical too. Like, he doesn't share stuff with us off the. I don't even ask him. Like, I've talked to him like briefly in messages, but we haven't talked about any of this stuff. I would never ask him because I just know it. Like, so people want to know if he's going to come back on the shows. I haven't asked him. Like, people just keep bringing that up. I'm guessing no. Like, I know Attorney Betterow. If he wants to come on the show, he's going to hit me up and just say, "Hey, let's do a show." But do you think that's going to hold him back from doing the shows because he could be possibly part of the appeal? That's what I'm guessing.
Yeah, I think potentially. Now, having said that, the appeal, like I said, any appeal is based on the record in front of the court. And so, if he comes on a channel and says something, that in and of itself isn't a court record. But the risk is, of course, the Commonwealth would, put it in a pleading or something like that and cite something that he said to try to help fill in that gap. If he says something on the record or says something on your show about the nature of the conflict, because of Turtle Boy or something like that, then yeah, the Commonwealth can potentially put that in a pleading to the court and then that is now considered part of the record. So I would expect he's going to continue to be circumspect about the case, at least until, the case is done. I don't expect a conviction. I didn't expect it the first time. Kind of, I think like many people, pulling my hair out a little bit about how on earth did this jury hang?
The jury tampering comes up. It's right. That's another wild thing that we could talk about tonight.
Yeah.
We had a couple of questions about Betterow. This is
Yeah.
the first one I want to bring up is here it is. Debbie W says, I don't know if you saw Runkle, who I love Runkle. He says, Runkle's take on the Betterow decision. He said there is a conflict there could be a conflict down the road with Betterow. It could conflict the entire defense team off Karen's case. Thoughts?
Yeah, I mean that would certainly be possible. They would have to essentially establish like a firewall with any type of confidential material that Mr. Betterow has access to because of his position in this other case. They would need to be very, very careful about walling off the rest of the defense team from that. Or the risk is, yes, if that's a conflict, it taints the entire team, and then the whole team can be struck. That ironically seemed to kind of be what Judge Cannoni was getting at in her ruling, because she was saying, well, but then he wouldn't be able to fulfill his duty to use all of the information and resources and stuff available to him to benefit his client. If he can't use what he knows in Turtle Boy's case to benefit Karen Read, he's like not effectively representing Karen Read. But that's like the core of a waivable conflict is that type of a situation where you acknowledge, under every other circumstance, you'd be expected to, advocate for me with every resource at your disposal. But because of these circumstances, that's a limit we have to put on it. And I'm willing to accept that trade-off in order to have this person functioning as my lawyer. So, I mean, yes, I definitely agree with Ian that's possible. But I also think that it's something that can be managed.
Negotiated. I love that. Like it can be managed, negotiated. You can, when it comes up, firewall. There's a lot you can do.
Mm-hmm.
Amber says, will Judge Bev's comment, by my count, she has at least 4 lawyers on her team already on Betterow's denial, have any negative impacts if this is appealed?
Yeah, it won't necessarily have any negative impact, but it certainly isn't going to help things. With the choice of counsel, it's very clear. It's up to the defendant to decide. The court doesn't get to decide what they think your appropriate representation is. And so, if you want 10 lawyers, that's your right to do that. So it does make it look a little bit like she's injecting herself into decision making that really isn't hers to make. But they tend to be very forgiving of commentary, I guess, like that, if it's not strictly critical to her reasoning about why she's denying the motion. It's just sort of this like snide little aside, more than anything. They're probably not going to like raise that in the decision or rely on that as a reason to reverse her or anything like that. I just lost your sound. I don't know if
oh, it's me mute. It's me muting. He's so quick on it. Thank you. I was just say I just lost my bet with my mods. This is they're trying to get me to go 30 days without hitting mute. I just lost the bet. It's been like almost 8 days or something. I was doing good. But Attorney Burkhart, you have Twitter, you have YouTube. I also see you have a Substack, right?
Yes, I do. Those are my main places I'm on.
So I want to make sure people follow you if they're not. I know tons of people are already following you on YouTube and Twitter as well, but I want to make sure that people know everywhere they can follow you. Are there any other places people should be checking you out on besides Substack too?
Yeah, those are the main places. I'm occasionally on Instagram, but I don't really put like legal content on there. That's like, so I spent a couple months in Chile this spring, and I took lots of photos, and so I post stuff like that on Instagram. If you're interested in that kind of thing, that would be the place to look for it. But as far as legal analysis and content, Substack, X, and YouTube, those are the places to find me.
Excellent. We're going to be posting those in the chat tonight. Just pinned Andrea's Substack at the top in the YouTube chat. So if you want to follow her, please just hit the click the link, and put your email in there. You can follow her there as well. We got a lot of questions coming in. A lot of people asking questions in the super chats. Here's one.
I just saw a pretty significant development.
Yeah, with the Supreme Judicial Court come down with something. That's happening. Is that happening now? What's going on?
Yeah, we got a certificate of appealability from the U.S. District Court out of Massachusetts. This is relating to the habeas petition, and so essentially, what this looks like is it's just kind of part of the procedural process of how this works. She's essentially argued these errors relating to the double jeopardy and the declaration of the mistrial. She's arguing based on that retrying her is a violation of double jeopardy. So it went up through the appeal process, through the Supreme Judicial Court. They denied everything. She's now gone into federal court to ask for a writ of habeas corpus. And the first kind of hurdle that they have to clear for that issue to be considered by the court is to decide if they really have the authority to consider it at all. And so that's the certificate of appealability question, where they look at sort of what are the necessary predicates for them to look at a ruling in a state court on an issue like that. And so they have apparently just today, issued this certificate of appealability, meaning, yes, they find that this is an appropriate decision for federal habeas corpus review. So they will now go on to evaluate the merits of the arguments that she's raised about double jeopardy and about the manifest necessity for the mistrial.
Wow, that's huge news.
Big
That's
news.
good, great news for her. How does that proceed? Like, is it something that gets done before April 1st, or does April 1st get pushed back? What do you think? Like, what's going to happen on that?
That's the $1 million question. I mean, when the district court judge initially set the scheduling order on the habeas petition, he acknowledged, this is coming up real fast. He wanted to try to accelerate it. So they had to brief the case very quickly. They had argument on it, like a week and a half, maybe 2 weeks ago. Also very recently. So we know that he's aware that this is kind of on the horizon. But judges are busy. Who knows? This is a very accelerated time frame to get a decision on the merits down from a federal court. So the other possibility is that somebody could at this point, and it would likely be the defense, because they're the ones who would be invested in the outcome, asked to continue the trial and raise the fact that that this issue is still pending in the federal court as a justification for it. The problem that the defense kind of has is that the remedy for this problem is not having to go through the retrial. And so if they, end up having to go through a retrial, and then they get a federal court decision that says you didn't have to go through a retrial, well, they've been harmed by that as well. So there is a little bit of a justification there. Hold off until we at least get a final decision on whether it's even constitutional for this trial to go forward.
Seeing some people in the chat saying it was denied, though. I'm not. It's funny because some people are saying it's great news, and then other people, who knows? I'm wondering if we could bring it up today.
Well, what I'm seeing, I can send you the link. I get all of my Karen Reed pleadings from Dee Dee over there.
I'll have to look on
over
Twitter,
there on
right?
X. Dee Dee is amazing. She is at Suspicious Sauce if you're looking for the handle. But she will screenshot all of the pleadings that come in. So this is a very short 2-page one. And it says that it just kind of, lays out what the procedural context is, the questions that are presented. And let's see. Oh, I see. Okay. So they denied the habeas petition in its entirety. I see what people are saying. On March 13th, 2025, the court denied the habeas petition in its entirety, ruling against petitioner on the first three grounds and determining that it need not reach the fourth ground. Okay. So they've denied her request. I see what people are pointing out there. It's kind of buried in the middle, so I didn't see it when I was first going through. Then for them to be able to appeal it, there have to be these certain predicate findings that are made. And so the court has basically found that she's made those findings that justify a finding that she can appeal this ruling. So this would then, if she appeals it, goes up to, what are we in? Are we in the Seventh Circuit over here in the District of Massachusetts? It's giving her permission to take it up to the next level. So yes, thank you for the correction on that. They've denied her petition.
Yeah, this is breaking news, so we're
Yeah.
just trying to adjust to it. We don't
Yeah.
get to read everything while we're doing a live show. This is
Yeah.
difficult, but it's good to get it out there.
Yeah.
You've
So
mentioned
yes,
eight.
that is unfortunately bad news for Karen. It means that they are finding that basically no problem with the mistrial declaration. They aren't going to find that there were other things that needed to be done before the mistrial could be declared. They aren't going to find that the fact that the jurors came in after the fact, 5 of them, to say we had unanimously acquitted of the murder charge and the leaving the scene charge. They're not going to consider that an acquittal. They just go by what happens in court. So this is, it's not a favorable outcome for Karen. Unfortunately, from my perspective, it's really it's not an unforeseeable one. When I had looked at this and kind of looked at the legal framework while it was in the Supreme Judicial Court of Massachusetts, I did look a lot of the case law myself, and it's not favorable. It's not favorable to her. There really wasn't a way to get around that. It's kind of one of those situations where the law is what it is, and it's good for people to know that, because the law maybe needs to change. And so we need to be aware of that and kind of aware of what it is and how it can play out and stuff like that. If we want to exercise our rights and participate in the process of self-government and stuff and change the way that things are done. So whether or not it's a good thing is kind of a separate question from what lawyers do in this type of framework. Unfortunately, the law was really not on her side. She did have a little bit more going for her in the federal court under the federal standards and the federal case law. But this one, unfortunately, it was always going to be an uphill battle.
Thanks. I was hoping it was going to be great, but it is what it is. I wasn't expecting it to go her way. I really wasn't on that.
Yeah.
This is you brought up Turtle Boy today, Aiden, because he, on the latest prosecution, has put out a witness list, and they have him on the list now. And it's funny because the judge Canoni said she was going to keep all that stuff about witness intimidation and Aiden out of the first trial. She mostly did up to a certain point, and then she let witnesses just like Jen McCabe go off on. They're harming my family.
It was Allie first, wasn't it? It was Allie that I can't remember the order, but I sort of remember that. Yeah,
I think it was the daughter. Yeah, she was probably the first one. So then now they're trying to bring him up as a witness. How is that going to go? And is the judge again doing things one way one time and then changing things this time? Is she going to let them have Aiden Carney as a witness? And would they actually bring him on the stand? And what are they doing? How does Aiden Carney help the prosecution convict Karen Reed for murder? I'm wondering.
Yeah, so they are also asking, since this is a new trial, we're not bound by the previous rulings on the motions in limine, right? So this was also litigated before the first trial. She said basically, no, this is too far afield. We're not going to get into that. Now we have a new trial. They get to ask again. The defense gets to ask again on certain other things and so forth. So she's considering it anew based on what's known at this particular point in time and kind of what the arguments are at this point in time. So Mr. Brennan is arguing that it's consciousness of guilt, that if she's directing Turtle Boy, to go out and intimidate witnesses, or however the Commonwealth wants to kind of color this or characterize it, that is indicative of a guilty conscience, right? She doesn't want to get caught. She doesn't want to get convicted. So she's trying to, distort the system and the process so that doesn't happen. Now, this kind of evidence is fairly common. It's fairly common. I see it a fair amount in, very common in like domestic violence cases, just because it happens a lot. People work through the grapevine, or they, will even just themselves on their recorded jail calls, be trying to get people change their testimony and stuff. So it is fairly common for that type of thing to be admissible. The problem is, at least from what I personally have seen of the messages between Karen Read and Turtle Boy, the stuff that's been publicly out there for a little bit, there's nothing like that in it. She's sharing information with him. I think that's pretty clear, and that's pretty well established. But he's an investigative journalist. He has a platform. This is a high profile case. She's trying to clear her name. Like, it's really not at all the pretty clear situation it is when you got the guy on the jail phone calling the girlfriend who has the protective order against him, saying don't show up at court, and they can't do anything about it. So that's where I think this is still a bit of a reach, but it's going to come down to what Judge Cannoni thinks about the situation as it stands right now. And I'll tell you, one of the things that I just suspect is in the back of her mind, it seems to me like, based on how she handled the issue with Alan Jackson and the whole, candor to the tribunal issue that came up, she didn't like what she saw in that impounded Gretchen Voss, off the record part of the interview. She called out parts of that. She didn't like how Mr. Jackson behaved in that. And so I suspect, there's a possibility that type of thing can color her perspective on, what is Karen Read even trying to do here? Something like that. So we'll just have to see. It'll be argued. We'll have it come up more than likely in the hearings next week when they go into motions in limine, why the Commonwealth thinks it's relevant and should be admissible this time. But I personally, looking at what I know, what I've seen, and kind of what the standard is, to me, it's a real reach to say that these types of communications reflect any kind of intent to intimidate witnesses. It's just sharing information, and she has a right to do that.
Absolutely. And it's funny because I know Aiden, and I think most people that know him like I know him would recognize that he's not someone that's going to take orders.
Mhm.
That guy, like, I would never say, "Hey,
Not
Aiden,
my impression.
why don't you do this for me?" Like that's just like insanity. Like that's just asking for trouble. Actually, if you
Mhm.
try to like bully him to do anything. So it's funny that they act like he's at her beck and call and doing everything she tells him to do. And it's
Mhm.
like, no way, no way. That guy
Mhm.
is way too independent.
Mhm.
Yeah.
Yeah.
So yeah.
So there is always the risk too that a strategy like that can backfire. Maybe it's allowed, and you put Turtle Boy on the stand, and then Turtle Boy is able to show the jury who he is and how he's handled and so forth. Just makes it clear how ridiculous that type of allegation would be. He is clearly not a slouch. He's very, very quick, very sharp. He would be, from my perspective, I would be
Handle.
nervous about having
Yeah.
to cross-examine him, or in this case, it'd be direct examination. Is even harder with somebody who hates your guts to try to direct
Yeah.
examine them.
Especially
Uh,
him on this
yeah,
case too. Because
Turtle Boy.
I think, yeah, I think he would turn the jury. Like I think he would throw some stuff in. They'd be like objecting every 2 minutes to something he said.
Yeah, and it's a situation where you called this guy, so
Yeah.
you're now, you kind of open the door. You want to shut him up, but it's very much a be careful what you wish for situation. Turtle Boy has the potential to be a very dangerous witness for the Commonwealth, so it just might be a be careful what you wish for.
How about this comment from Peter that the judge doesn't
Mhm.
care about a post-conviction appeal in the case. Appeals take years. She just wants Karen put away now. You think that's a relevant comment about the judge on her thoughts?
Yeah, well, this is routine in criminal practice, and it's maybe a little bit different in Massachusetts because your judges aren't elected, but there's still politics involved. Uh, Nobody ever gets elected on a platform of let's be fair to criminal defendants. People get elected on platforms of let's lock people up, let's throw away the key, let's be harder on this and in that and the other. And so there's often just a sense of my experience has been it's just often easier for the state, the government, just rule in their favor, give them what they want, and then if somebody is going to go and do something that favors the defendant, let it be those folks up there on the court of appeal. Trial judges don't like being reversed. It's not a good thing. It doesn't help them. It's, I suppose, maybe a little embarrassing, but not really. Like, how many people even really find out about it? The lawyers who read the advance sheets that come down from the courts and see the opinions coming out, they see it. But does it really matter all that much at the end of the day? Maybe not. And the thing about Judge Cannoni, she's been reversed quite a few times. And so this isn't a situation where it'd be like something new. At this point, it's kind of like old hat. So the whole potential like embarrassment, shame factor of getting reversed isn't necessarily going to have it isn't necessarily going to have a lot of influence here. You just have like, it's almost like diminishing utility every time. Every time you get reversed, it's going to be a little bit less bad. And so, yeah, there's often this sense of, well, we'll just get our pound of flesh and let the court of appeals go and sort it out. I'd love to say that that's unique to this case and to this situation, but that's actually, from my perspective, that's pretty systemic and honestly and sadly kind of normal.
It's sad. It is like just frustrating too that people have to pay that kind of not for not caring for the
Hmm.
judges not caring about it.
Hmm. Hmm.
I is a comment about Brennan or Brennan. Uh, he said, "I can't." And then Brennan said, "I can't trust any Tate team, so I'm going to review Morrissey's emails myself." Talking about the
Hmm.
cheesy banana emails, which is absurd on its face. What do you think about that? That he's saying that he's going to review the emails. It's not going to be a
Yeah,
Tate team. It's going to be Brennan himself, the guy who's getting a big salary or whatever we're calling it, big payments. He's getting rich off this case. Brennan is. So, what do you think about that kind of comment?
this doesn't make sense to me. I mean, the reason why you have a taint team involved in the first place is so that they're disinterested. Brennan is an agent of the Norfolk County District Attorney's Office. Morrissey is at least structurally his boss. So there is kind of a conflict of interest here, and there's also the conflict of interest that just relates to his interest in prosecuting Karen Reed and getting a conviction. He's going to want to get a conviction with the incentive to potentially not be so broad in his reading of any potential emails that are out there and in terms of whether they establish misconduct or anything like that. I have a really negative view on prosecution run teams in general. This is like kind of become a new thing in the past. I don't know. I feel like it's been maybe the past decade or so that they've started to be real common. And I think electronic, like digital discovery and digital forensics have a lot to do with that because we just have access to so much
Big.
more information. And like if police are going and doing a search, they just always necessarily kind of end up taking more than you would get if you're like just going through the file cabinet. You can see, oh, this letter's addressed to that someone, I'm going to go ahead and leave it there. But with a digital type of process, you scrape everything. So similar example like is down there in the Diddy case, right? The Diddy case, they went there, they raided his jail cell, they seized all of his papers, and a lot of his papers include attorney client communications and notes and legal research and stuff like that, that, at least facially is supposed to be protected. It's supposed to be confidential. And so what they do is they just hand it over to an independent prosecutor run taint team, right? So the idea is these aren't the actual prosecutors on the case. They're completely separate. They don't have any incentive in the outcome of Diddy's case or anything like that. And they're going to go through and review everything and decide, is this confidential? Does this fit within some type of exception to attorney-client privilege or work product privilege or something like that? The reason why I have such a dim view of it is because prosecutors have the incentive to read things in their favor and to interpret the rules in their favor. It's from my experience, again, I don't have statistics on this or anything like that, but just kind of been to a lot of conferences with a lot of defense lawyers and stuff. It's way more common for, I'm going to take that back. That may not be true. I'm just thinking in terms of the movement across the aisle, defense side to prosecution side versus the other way and stuff. I would say typically, I think what happens is that it's more common for people to be defense lawyers and then move into prosecution early in their careers. It's more common for prosecutors to start off that way and then move into like private defense often later in their careers. So if you're a prosecutor, it's not that common that you've already had experience as a criminal defense lawyer. So you just don't really have the perspective of what the defense team is doing and how, you just develop tools and strategies and have ways of communicating and things like that to sort of keep things within the lines while doing, the best job that you can for your client. So they don't necessarily have the perspective on how this type of situation actually works. And then they also have the incentive to, look at these things and take a dim view of like, oh, well, this tends to prove, the crime fraud exception or something like that. So I don't think much about prosecutorial taint teams anyway, but in this particular situation where the guy who is supposed to be in trial in front of this judge on this case is the one that's supposed to be reviewing the emails, I have a hard time seeing how that isn't a clear conflict of interest.
But Bettero's a conflict, but that's not. It's just funny how it always goes for the prosecution. They can have all the conflicts they want.
I mean, which takes us to Dr. Crosby, right?
Yes, you want to talk about
the
Dr.
rules
Crosby
for thee versus rules for me, and how the standards just are not. I've been glad to see so many new faces and new voices and stuff. Getting familiar with the Karen Read case and kind of getting higher profiles in talking about the Karen Read case. Because one thing that I think a lot of lawyers are often just really hesitant to call out judges, and especially bias. There's kind of a certain amount of being a prosecutor in a robe that, again, it's kind of accepted as the norm. Like we're just so used to it. Like that's just how it works. Prosecutors tend to be elected to the bench. Judges tend to hang out and socialize with prosecutors and police officers and folks like that who have a lot of political power to leverage, much more than your average criminal defendant does, better organized and stuff as well. They hang out in court every day with the prosecuting attorney. They might only see the defense lawyer, every few months or so. So there's just these alignments that naturally tend to take place that influence the court to be friendly with and kind of allied with the state and with the prosecution. So you just kind of accept that as the norm. Again, maybe it shouldn't be that way, and maybe we should have rules about that, or like some way to kind of be able to manage that.
How do you manage that? How can that be reformed? Because I feel like that is such a big part of this. Like the institutions just aren't fair. Are there any types of reforms that you can think of that would help change that?
Well, I think, for example, like in this particular case, there's a lot of things that can be done to improve the situation, and so just a very basic one that could be done right now without any type of structural change at all. Um, we could focus on electing people from the defense side, elect more defense attorneys to the bar and not as many prosecutors. That might start giving you a shift. Now, of course, again, in Massachusetts, that's not necessarily an option. You guys don't elect your judges, but in places that do, that's something that at least you can hope might get you a broader perspective on the bench, although ultimately they're still going to be subject to those same influences of, these are the powerful people, these aren't. So here's who I'm gonna align myself with. Some structural things.
Yeah, I would say, following up on that part, I think that would be a good
Mhm.
question for anyone running for governor.
Mhm.
Because we had this Governor Charlie Baker. Well,
Mhm.
I didn't dislike the guy or anything, but it seemed
Mhm.
like every judge he put on, you know, every judge he nominated, former Mass State Police or
Mhm.
former, like you said, prosecutor. That's it.
Mhm.
Like, it'd be like,
Mhm.
who's high in the state police that has a law degree? Who's a former prosecutor? That's my next judge pick. Like, every
Yeah.
single time. It seems like every time. So I think that
Yeah.
we're in Massachusetts, we have to start asking that question to people running for governor. Will you put more defense-oriented people on,
Mhm.
nominate them to be judges in Massachusetts? Because
Mhm.
it's obvious here. I'm sorry I interrupted you. You were about to make another point.
Oh no, it's totally fine. And I mean, part of the challenge too, anytime you're dealing with politics, of course, and political solutions, is that things get political. And so it's like, as soon as you bring up a certain suggestion or something like that, now suddenly it has to be filtered through the partisan framework, right? Like, who's even going to introduce? Is this going to be a left wing? Is this going to be a blue state proposal? Is this going to be a red state proposal? Like, for me personally, criminal defense reform is not the type of thing that should be a partisan issue. Like, there's just as many reasons to be concerned about it from a Democrat standpoint as there are from a Republican standpoint. I think if there's one thing that, like, the first Trump administration really, I think, clarified and sort of light bulb moment for a lot of folks on the red team, is how prone to abuse these systems are, how easy it is to abuse them, how easy it is to distort them, use them against your political enemies, and so forth. So it really isn't something that we should be like, but bipartisanship is very, very challenging. It seems to be a dirty word in this day and age. So anyway, that's always a
Wish it was.
limitation when you talk about these types of structural fixes. Um, Another thing I was going to mention was that, for example, when they did move to disqualify Judge Cannoni right before the first trial,
Yes, it is.
and so I read that opinion, and one of the things I remember standing out about that was that the way that the Massachusetts case law has developed is that they're not allowed to use the trial court's rulings against a party to show that the judge is biased against that party. It's like, just because she denies your motion every single time and she grants it in favor of the Commonwealth, like, they're not allowed to consider that as evidence of bias. To me, this is preposterous, because that's the nature of what
Uh,
bias is. It comes clear in the actions. It's a thing that you do. It's a favoritism that is reflected in the court process. So that's the type of issue where, potentially through legislation that could maybe be changed. That's something that through advocacy in the courts, it's a harder pathway, but rules do change. Precedents do get overturned. You can make arguments in an appellate court about why the law is bad and why the law needs to change. So that type of thing can potentially help as well. I mean, just, yeah, vetting processes for judges. How do we retain judges? Maybe have some type of retention process where there is, judges have to be ranked or have to be rated or something, evaluated by a
I would
panel of
love that.
prosecuting attorneys and a panel of defense attorneys.
That would
Just things.
that would be great if they were
Yeah,
rated. I love that idea, rating them.
yeah. So, I mean, I think there's a lot of possibilities for handling stuff like that. You just have to, there has to be a will to address it. And I'm of course a dyed in the wool defense attorney. From my perspective, there just rarely is political will to make those types of changes. People, by and large, tend to like hanging judges, and it isn't until the injustice lands in their own backyard, that it tends to get their attention, and then they want to change it.
That's the real problem. I mean, we could talk about all the solutions, but if the political will isn't there, which it generally isn't, like, that's
Hmm.
exactly it. Most people want law and order. They want I mean, it's
Hmm.
just the reality of it. We have a
Hmm.
personal question here. You don't feel pressure to answer this if you don't want to. Nina, I think she's asking it because she's from here. She says, "Andrew, are you from Germany? Do you speak German?"
Ich spreche kein Deutsch. My husband, I married into a family with a German history. I do not have German in my background as far as I know. However, my grandmother and my father both speak German. My father and my mother lived in Germany for a few years when I was in college. So I've been to Germany a few times. It's a beautiful country, but no, I really don't speak German. I know enough to say I don't speak German in German.
That sounded good though. That was like me with French class in high school. I learned to say, "I don't know, je ne sais" what was it? "Je ne sais pas" or something like
Je
that.
ne
I don't
sais pas.
know.
Yeah,
I don't
je ne
know.
sais pas.
Je
Je
sais
ne
pas.
sais pas. Now I do speak
So
French because I lived in Belgium as a teenager. I've forgotten a lot because that was a long time ago. But yes, I speak a little French.
which is great. I wish I
Je
took
parle un tout
Spanish
petit
though.
peu de français.
Yeah, I think Spanish would have been more helpful for me. Like, I worked in
Yeah.
a lot of kitchens ever in, mowing lawns and just Spanish is so much more universal. Um, some more here's a good comment. It says, "Andrea is my favorite love. I've been following her since she started her channel. She's an amazing human being and so incredibly intelligent." That's from Andriana
Aw,
B.
thank you,
I love you here.
Adriana.
Yeah.
It's an awesome thing
Uh,
to say.
yes, and then we had a question. I'm losing my questions. We got a lot of super chats coming through. Uh, where is the one? I'm sorry. We'll go with this one. Hey, Andrea, Bev doesn't. Oh, we already read that one.
Yeah.
Sorry.
Yeah.
I had some
Yep.
good ones up and I lost them. We could put this one up too. This is
Mhm.
going back to Turtle Boy. Theoretically, if Turtle Boy takes a stand and blames Karen
Mhm.
Reed for everything, Betero can't represent Karen Reed, right? He can't
Mhm.
cross his own client. That's the conflict.
Mhm.
Do you think that would happen? I don't think that would happen, though. Everything I know about these 2, I don't believe that would ever happen, Nina.
Yeah, it doesn't seem likely, and the thing is that the person who's in the best position to know if that's likely or not is Bettero. And so you
Exactly.
to some extent have to kind of defer to him and his judgment on that. Yes, that is the potential conflict. If that were to happen when Turtle Boy is on the stand and he goes after Karen Reed, the whole issue is now the defense team has an incentive to undermine him, to challenge his credibility, to impeach him, or whatever. And so that's the risk that they would face. And so the concern is, well, if Bettero has confidential information about Turtle Boy, it's in Karen Reed's interest for him to be able to leverage that on her behalf to show, hey, Turtle Boy's lying. He's a liar and whatever. And so yes, this is the nature of the conflict. The issue, though, is again that can be firewalled. If the only access to the information is Bettero, then Bettero firewalls it from the rest of the defense team, and Bettero doesn't participate in the cross examination. That's how you protect both of those interests. So yeah, this would not be an ideal situation. No ways about it. But I'm just not seeing that it isn't something that can't be waived. These are the types of situations, honestly, that I've always practiced in small communities. The town where I spent most of my criminal practice when I was doing trial work was like 30,000 people. So it's not huge. They're fairly small, and as a result of that, you often end up in kind of marginal situations because there's only so many public defenders, and there's a lot of criminal clients, and there tend to be a lot of overlap in who the criminal clients are and stuff like that. So it's not at all uncommon for you to have represented somebody that you've learned information about them as the in the course of your representation, and then later on it turns out that like they're a witness in another case or something like that. So yeah, these types of conflict rules are something that I think, just depending on the nature of your practice, you might be more or less comfortable with navigating them, and judges too can be more or less comfortable with actual potential conflicts, and how likely are they to ripen into an actual conflict that's going to require an attorney to be booted. Are you willing to roll the dice, willing to take the chance? Are you willing to give more deference to the attorney's judgment? Are you not willing to give that deference? There's just a lot of variability in that. So yeah, I think this is a very good point. It still, to me, doesn't solve the problem, though, if we don't have a record of any of that in Judge Bev's ruling, or
Not even an
something.
affidavit from Brennan. You know what I mean?
Yeah.
Nothing on the
Yeah.
record from him.
Yeah. All we know is just that there's kind of this inchoate, potential for a conflict that really hasn't been spelled out.
It's maybe, possibly. This is a good question from Nina. This is the one I was looking for. Andrea, your thoughts on Bev allowing videos without metadata? They could create AI generated videos. Is this a new era? How to deal with it?
Yeah, this is a new era. This is absolutely a new era. And so how do they deal with it? I mean, the conventional rules, we're still dealing under conventional rules of evidence that have really not adapted much to the digital era. And so under the conventional rules of evidence, no, they don't have to show metadata. Metadata might be a way to help authenticate something. Authentication is the process of establishing that the exhibit that you want to introduce is in fact what you are, what it purports to be. But conventionally, the way to do that is you just have a witness that testifies. Yeah, this is the scene where I was at, and this photograph appears to depict the scene, and it's a fair and accurate representation of the conditions at the time. That's all they need. Like, they don't even have to show who took the photo, when the photo was taken. Those are your basic requirements for it to be admissible as evidence. So that burden is extremely low. How to deal with that, it kind of gets shifted to the other side. It gets shifted to the other party. And so it puts pressure on the defense to raise it, to, get it, to review it, to analyze it, to understand it, to identify problems with it, to cross-examine about it, and so forth. Now, where, from my perspective, this whole situation gets real sticky is when the metadata not only isn't being admitted, but it's not even available, and it's not even being turned over to the defense, right? Because apparently some of these forensic processes that they've used have resulted in destroying the original metadata. That to me is a problem. But it's not, I'm just telling you, under the kind of rules of evidence the way they are right now, that's not going to be a basis to exclude it. What it will be is it will be something the defense should absolutely, at a bare minimum, have full leeway to cross-examine them on. This is a basic thing that you could do to show that this document is, or that this, this exhibit, this video is unmodified. You guys are trained forensic experts, you're evidence collection and preservation experts. You go through all this training to teach you how to do that. You knew that this was an important case involving the death of a Boston police officer, and yet you didn't bother to preserve the objective proof that this thing was filmed on this day on this camera and hasn't been modified. That's like the bare minimum, that they need to be allowed to do. My perspective, I think there should be a spoliation instruction on this. The spoliation instruction is Massachusetts has a Form 1. Many states have a Form 1. And it basically tells the jury that if there is evidence in the possession of a party that that could have been produced and shown to the jury, and it's either been destroyed or lost because of the fault of that party, you can and perhaps should infer that the reason why you're not seeing it is because it's not beneficial to that party, like it's bad for their case. That to me is entirely appropriate in the situation, given who these people are. Again, these are the folks that are entrusted with preserving evidence, trained in how to do it. They should know the importance of it and have taken every step to be able to do that. So not having done that, I don't think there's a good excuse for it.
Instruction, is it done by the judge or is it done by the defense? How does that happen?
If that
What does it look
instruction
like?
is given, it's part of the total and jury instructions that are given in the case. So typically it's going to be in that packet that she reads at the end. But you can sometimes also with the destruction instruction ask that it be read at the time that you're dealing with that particular evidence in the trial. So they would get it, at a point where it's relevant and it's going to stick in their mind.
A couple of comments and questions about this here. Mr. Monk's understudy says your real-time analysis of Bukaki going over Karen's drinks was so accurate and responsible and astute. Thank you. Can you tell us about that? What did you find? Because that became a big question, it seems like, for the jury. It seems like the drinks was a big issue for the jury.
Yeah.
What did
Well,
you
you might recall
down?
this particular bit of the testimony. It was late in an afternoon. I want to say on like a Thursday or something. It's in a real lull point of the trial. And of course, with Mr. Lally, it would often get a little bit difficult to, keep your attention sharp as
I
the
fell asleep
trial
at
went
one
on.
time. Yeah.
And, all of the tools that we have for the jury, we don't actually stick them in that Clockwork Orange chair, with the ice thing up.
It was the day that Betterow was there, and he was almost nodding off, and people were giving him a hard time.
It was really bad. And so I noticed that. I noticed it from just watching kind of, the other commentary that was happening at the time. And certainly my own feelings. You're just like, oh, you're trying not to fall into the nap. Well, we knew that this was very important and that these details were very important. So we focused and we watched what Trooper Buchanan had to say about the drinks that he claimed that he was seeing on this video. Well, they're showing us the video in the court. We're watching the video with our own eyes. And so we just paid attention to what's there on that video and refused to be gaslit by Trooper Buchanan about what it was showing. I mean, there was all kinds of occasions where he would say, oh, and there she is getting a drink. You can't see anything. Like she's just kind of standing there. You can't see a glass change hand. You just, it's sheer gaslighting. And we had kind of anticipated this too, because that was going to be easy ammunition for the defense team, because Trooper Proctor had in his affidavit, he had signed sworn testimony identifying specifically at these timestamps on the video, you see Karen take a drink. At this timestamp, you see her get another drink. So they had to back that up. And so we watched the video and we watched them try to do that. And we saw major discrepancy between what Trooper Buchanan was telling us was there and what we could see with our own eyes. So that is something I do hope that it's hard to do for the, again, it's a lull, and that's kind of part of the strategy. You're not paying that close of attention. It's easier to listen to the guy than it is to, stay sharp and focus on the video yourself. But that's going to be really important for the defense to find a way to go back, in my opinion, and call him out on, well, you say you saw this. Here's the video, we just looked at. We didn't see any of that. Just some way to point out that gaslighting and call it out so that it doesn't have so much power.
So I feel like that part seemed very fuzzy too. It just, and not believable to me. I was like, this isn't what happened. I just don't believe.
She did not drink 12 She did
Exactly.
not drink 12. What was she drinking? The vodka
Vodka
sodas.
soda, yeah.
Yeah, the Tito's. She was not drinking 12 shots of Tito's, and not showing any perceptible signs of that, with her in the condition that she's in, the health that she's in.
Exactly.
Um,
And
it's
how
just
small
not.
she is. I mean, I've
Yes.
seen her in person. She's small. She's a skinny person. Like,
Yeah, she's
like
very
there's no
petite.
way. Yeah,
She's very
petite. That's the
petite.
word. Yeah.
So,
So yeah, it's wild. Wild some of the stuff that just got through last time. Here's another question about the drinks,
mhm,
but it's about somebody else.
mm.
The Karma Believer says, I want to see receipts for how many and what drinks Higgins had at the bar. Didn't he only drink whiskey?
Yeah,
What
that's what he
happens if he had a
said,
Bud
right?
Light or something? What happens if it was a Bud Light? Because he said he left the house because they didn't have what he wanted, right?
Yeah, that was the whole story, which I found completely incredible, as well. I'm sorry, there's no way that a Boston party guy who has parties at his house doesn't have a well stocked liquor cabinet with a variety of Irish whiskey, Scotch whiskey, Kentucky
We don't
bourbon.
even
I mean, all of it.
yeah. We don't even drink and we have it. Like at my
Yeah.
house, we don't even drink, but we have it. We have it. If you wanna come over and have a whiskey, it's here. It's in the closet. It's there. I can't imagine. Yeah, that's just and that he would leave too, though.
Yeah.
Like, yeah, I'm not buying that. I think
Yeah.
if someone offered him a I don't know, like you said, a Tito's with soda or something, he'd probably still drink that. Come on.
Mhm. Mhm.
Um,
No, I won't blame anybody for turning down the White Claw. I really won't. I myself have been known to turn down the White Claw.
is that not good? I don't even what
Not
yeah,
my
what is
thing.
that?
Not
Yeah.
my thing. Oh, it's like the old Bartles and James kind of, the old
Oh, yeah,
maybe
yeah.
even like a
Wine
Boone's
cooler.
Farm, it's like
Yeah, yeah.
a fruity,
Yeah, I know
fizzy,
all those.
alcoholic thing.
Now you're
It's not
speaking my
good.
language. Gen X, the Bottles and James,
The old Booms
Mad
and
Dog
old
2020,
Mad Dog. Oh
yeah.
yeah, those were the days.
Oh, yeah. Uh, so funny. There's a few more questions. Here's a good comment. I love this comment. Freedom Lover says Brennan just put Aiden on the witness list so he couldn't attend the trial.
Mhm.
Do you think there's any truth to that? That to me seems maybe what I mean.
I wouldn't rule it out. I mean, I wouldn't say no. That's absolutely not the case. Of course, I'd buy that. Like I said, Turtle Boy is a very dangerous witness for the Commonwealth, and I'd be kind of skeptical that when push comes to shove, they actually do call him anyway. So yeah, if they get this added benefit if he doesn't get to be at the trial because he's under the sequestration order. That's a win for them.
Positive Vibes 1976 talking about Aiden. He says he's mentioned on his show that he wanted to be a witness in the trial. He said he'd be a great witness. Here we go. LOL. Love you guys. I know, right? He would
Yeah,
be a great witness. Like I just can't imagine that they want him there. It's you'd be
yeah,
giving him everything he wants.
yeah.
Um, Funny too, because it. Well, actually, we'll just skip over that. There's a lot to cover tonight. Yeah, I'm thinking about there's been a number of experts. Let's go to the experts.
Hmm.
I'm like, there's so many things I want to ask you tonight. But one of the
Hmm.
things is the defense has a lot of new experts that we don't know
Yes,
about. What do you
yes,
think? Like some of them we obviously know. We
yeah,
know who they're bringing back. We know some of the new ones, but we don't know them all. What do you
yeah.
think? Like, who are if you were doing the defense, what
Hmm.
kind of witnesses would you be looking for Karen Reed?
Hmm. So I would be looking for witnesses who are going to help me drill down on some of these defects in the case. And what I mean by that, like, if we like, we're entertaining the defense theory here that Karen's taillight was partially damaged when she backed it into John's SUV, and then ended up in the final condition that we saw it at trial only after it got to the Canton Sally port, and there was shenanigans with it at that point. This is our hypothesis, right? That's what I want to prove to the jury. So how can I strengthen my case to be able to do that? That's the type of thing for sure I want to look at experts at. I want to look at, I know there's been like some suggestion that folks might be able to see tool marks on some of these pieces of plastic. That's a great thing to have an expert on, a tool mark expert on, who can identify that type of thing. Somebody who can testify about materials, material scientists who can talk about, okay, this is the polycarbonate and this is the amount of force, and then how that's going to relate to, the multiple layers that exist in this tail light. It's like they didn't just crack the polycarbonate, they cracked the diffuser piece underneath, and maybe even like a little bit of the metal in the back. That type of thing I think would be very helpful. I'm sure you've seen, and your viewers have probably seen, I don't have the source right off the top of my head now, but there a guy very recently in like the last week or so did a YouTube video.
Smashing it. Yeah.
Yeah, it was
Yes.
a very, very good video. I found it very compelling, where he went in and kind of took apart the tail light in much the way that, so that it was essentially how we found it in the Sally port, and then turned it on so that you could see, okay, if the tail light was lit up in this condition, here's what it would have looked like on those videos. And the interesting thing about it was the diffuser, which is those pieces that they described as dimpled, that we saw in evidence. There are dimpled pieces from the taillight that are in evidence. That's the diffuser. And that essentially is what draws the light down from the taillight into the rest of the item. So when that's removed, the light can't move, and it just stays isolated up at the top. Well, that's clearly not what we saw on that video when she's leaving John's house at 5 some in the morning. So that type of thing is where I would want to focus my attention as an expert. The weak points. Where did they actually perpetrate this hoax? They perpetrated it on the taillight, and they perpetrated it on the video. So as many experts as I can get to go over to the video, which, we know that that's in the works. They've at least tried that already. They tried to get, somebody able to extract it. We got all these million stories about where it is and what they have and when they got it, and all that stuff that has just evolved so much. That's really where I think I'm going to focus the investigation, is those things that help you prove the frame up.
I think like a police procedure, I've been bringing that one up, like the way that the investigation was not handled the way it probably should have been. Is that something that they should bring as an expert
I definitely look at it. I mean, some of it is just so obvious. Like, you don't need an expert to tell you, like, red Solo cups are insane, like just beyond ridiculous. But in terms of things like best practices with conflicts of interest, with managing the access given that type of potential, somebody who can maybe like review other cases where the Canton Police Department has had to manage a conflict and see, like, is this similar? Do they do it the same way? Do they treat it differently? That's a type of situation that I think is definitely worth investigating, but just depends on kind of what you find, because some of it's so obvious that it's kind of low value. It doesn't really justify having an expert come in. But if you can find like good evidence, oh hey, last time they had a problem with a car that belonged to the sergeant's wife or something, they took it over to the state police Sally Port at this location. That kind of thing would be pretty good to know.
It's wild that they took it to the police station that had to recuse themselves.
Which is unbelievable. And then all the vanished video and everything. It's
wild.
Yeah.
Looking at the motion to dismiss. I want to bring this up if I can. Oh, I probably don't have it. This is Matt. He's an attorney. Tipanak. Have you heard of him on Twitter? He said the motion to dismiss was like a big waste of time. That there was. I mean, what do you think about their motion to dismiss on the defense side?
These types of motions are very unlikely to be granted. So in that sense, if you want to call it a waste of time, okay, fine. But I mean, the reality is most defense motions, you're on the back foot. You're not necessarily bringing them for that court. You're bringing them to make the record. And so that's, I think, the main reason why they brought it. Everybody knows that Judge Cannoni is not going to grant this motion. It doesn't matter what the Commonwealth did. She's going to, look at everything in a favorable light for them. She's going to make excuses for them and so forth. So the reason why they do it, they want it on record because I suspect they're anticipating there's going to be more shenanigans in the second trial. We're going to be just continuing to add to the list of the outrageous things that the government has done. So that's why they're bringing it. It isn't because they think it has a realistic chance of getting granted. It should, like in a fair and reasonable courtroom, these things should raise some pretty serious concerns. But the reality is that Judge Cannoni has already known about most of these issues, and she's just been very blasé, very lackadaisical about it. So this is for the reviewing court. This is so when the Commonwealth continues to bend the rules and not disclose things until late in the day and get in shenanigans with the witnesses while they're testifying and so forth. They already have this record when they go up on appeal to be able to say, first it was this and we asked and they didn't address it and it continued to get bad. Like, it just compounds the unfairness as it goes on.
Michael Proctor and his wife just put out a statement. Have you seen the statement that they put out?
I did. Yeah.
What did you think about this? I mean, was this? I'm just shaking my head. Even like the outlet that they put it out through was just, it's so wild. This is so. What did you think about it?
I don't know what possible benefit they think they're getting out of it. It's preaching to the choir. This is not going to move the needle for anybody that is on the fence or that has like paid close attention. It's very gaslighty again. Of course, that's like one of the Commonwealth's best strategies. The only way that I guess we could conclude that Trooper Proctor was an awful cop, he's an embarrassment to the badge, he's a disgrace to that department, is because we didn't watch the trial. No, it's because we watched the trial that we have this opinion of him. And so it's this very gaslighty, projecty kind of, if you don't believe us, it's because you don't believe our propaganda. It's because you're listening to propaganda, not because you have an informed opinion of your own. The reality is that nobody cares about Trooper Proctor unless they are paying attention to the Karen Read case. Like, outside of that context, it's a nothing burger. So the people that are following the Karen Read case, you kind of already have a lot of folks who are leaning one way or the other because we've already had a whole trial to watch. There's always going to be newcomers, right? Newcomers to the case, and in which way are they going to go? Well, most people, this is just what they don't like. Most people that come to a case new and cold, they wait for the evidence and then they make up their decision. So we're going to get a whole new trial. They're going to see it all over again. And then this type of statement just ends up kind of looking worse because it's so minimizing, what he said, what he did, the victim blaming, victim playing, like shifting how, after the awful things that he said about Karen and all of that. He's the victim in all of this. It's a very bad. It's just such a bad look. It's just such a bad look. From the legal standpoint, can they impeach him with it? Maybe. Maybe. Can they bring this up if he gets on the stand and he tries to play the whole I feel so I have remorse for my behavior and it was irresponsible and I shouldn't have done that, kind of card. Are they going to be able to bring this up and be like, well, but is this a statement from your family members that you endorsed where actually you seem to suggest that this was all blown out of proportion and really not something anybody should be excited about? Does that really sound like somebody who is taken any accountability for their action in this case? that's a possibility.
We done that on the stand the first time. Apologized to Karen Reed right in the
Mhm.
moment.
Mhm.
I just I'd say as a man, but just as a human being, you know what I mean? It's like
Mhm.
I don't know why he just didn't do that. But Carrie B says this is such a great point here because this is the other part that bothered me about
Yeah.
this. They keep saying the gag order, the defense is leaking. Well, we got Hank Brenning
Mhm.
talking about the federal investigation with all kinds of press behind the scenes. We know this. We know that he's
Mhm.
been leaking stuff before he even told the defense. You got
Mhm.
the DA who did the hostage video, who basically said
Mhm.
none of the witnesses knew the state, which is all lies, you know. And now
Mhm.
you have the state police guy and his family
Mhm.
right after the judge, you know, they're putting out the gag order, and you
Mhm.
know he's putting out statements like
Yeah.
what is the judge gonna do about that? She's just gonna ignore it, I'm guessing, but
Would
isn't
you
this
like
just such
to
a double standard?
would you like to take a guess?
Yeah, it's such a double standard. They do whatever
Yeah.
they want, and then
Yeah.
you're like, "Karen Reed, how dare you talk to Turtle Boy?" You know, it's
Yeah.
like,
Well, this is one of the big complaints I have with gag orders in general, and it's this can be a really tough issue because yeah, I represent criminal defendants. I do not want cases being tried in the court of public opinion by and large. I don't want to talk to the press about my case. It's just there is a process. We want the process to be as clean as possible. But you don't necessarily have any control over when things blow up and get high profile. Karen Reed didn't necessarily choose for it to go down that path. She's not the one who initiated the news reports and the just all of that. It was because of the nature of a Boston police officer is found dead. It caught the public's attention. So I'm really not a big fan of gag orders to begin with, because the problem is that the state always has a way to get their story out there, even if it's just like in this case, you have at least a few days. Well, no, I guess it was a day, but you have period of time before the arrest. You have that pre-arrest period where you have all this information about the investigation, and the crime and where it's leading police and so forth. And then it culminates in this arrest. And then at that point, everybody has to shut up. But so now the state story is out there and the defense has never had an opportunity to counter that. This is kind of the problem that we've seen in the Brian Koberger case over here in Idaho, where just this absolute like flurry,
sorry.
this feeding frenzy of information and speculation and anonymous sourcing and like all of this stuff, a lot of it turning out to be untrue and bad information. But there's been a gag order since the point of the arrest, so the defense has to use the court process, to try to set the record straight. They can't do what Karen has done, and use her voice and go to the press and that type of thing.
We've seen in the defense of, in the DA's office, this spokesperson, David Traub.
Hmm.
There's emails now showing that he was soliciting local media about the video that Michael Morrissey put out about all of
Mm.
this. Is that something that you think the defense should bring up in the trial or not? It just doesn't matter, or should they bring this up? Like, is it something that they should, like, maybe put Traub on the stand and say, why were you soliciting media for this? Why were you putting this out? I just wonder if because I feel like there has been such a concerted PR campaign from that DA's office going so
Mhm.
far to even, like, reach out to people on YouTube. And I feel like a lot of these antis are complicit with the DA's office. The DA office has been working with them, feeding them information, and even putting on pressure on people like myself. Like, I really
Mhm.
feel like they went way overboard this time. And I'm just
Mhm.
wondering, is there any way that that would ever come up in the trial?
Mhm. Yeah, I mean, I think that's a good point. We saw some similar stuff like that with Delphi and kind of the manipulation of the story and stuff. Over the course of a very very long investigation and what got trickled out and who it got trickled out through and that type of thing. So it seems to be a problem that is maybe a little bit more prevalent than I was necessarily aware of, but I'm certainly becoming aware of it now. I put this solidly in an it depends type of situation, and I'll tell you why. I mean, so first off, you would never put David Traub on the stand and ask him why he did anything. You never do that as the opposing side. You put him on the stand to just relate what he did. You don't ask him to explain it because God knows what he would come up with, and he'd come up with some bullshit about pardon me, but come up with some story about, oh, well, we did it because she was so clearly guilty, and the public is getting the wrong idea, and we need to set the record straight, just junk like that would be very prejudicial. But if there is a way that telling the story of how he interacted with the media and with these content creators looks sketch, like, yeah, you say, especially maybe you have the media being kind of made a theme of this trial. For example, the Commonwealth wants to bring in the Turtle Boy stuff, and maybe they're trying to imply or trying to represent that they were running it totally clean and they had no interest in trying this in the court of a public opinion. They were strict rule followers and wanted to keep it within the process of the courtroom. Well, now, he's impeachment. You bring him up and you show, well, actually, you have this guy who's been talking to Coffin Daffer and talking to, all these different other outlets and stuff. You have Morrissey given the big press conference, all that type of stuff. So, yeah, I mean, if those facts benefit them establish something, then, yeah, by all means, be prepared to bring that in.
Wild. There's just so much wild stuff that's going on in this trial. It's funny too, because when you said that, like I wasn't aware that DAs played like that. I wasn't aware that they, just stuff on this case that I knew things were political, but I didn't know how political they really were. It's been wild.
And I think, maybe I'm naive. I feel like this is still kind of limited to just the cases that catch fire, that just get so much attention, that it's like they kind of have to adopt some kind of strategy with it. Maybe that's, like I said, maybe that's naive on my part. But it is, again, just a little bit of a new environment now with independent media and, live streamers of this trial are getting more views than the primary.
Oh yeah, it's wild to me because some of the biggest local media, like the ones that are on TV and radio, I find out they're watching us. Like I'm just shocked. I'm like, are you kidding me? I've been watching you for like even Howie. Howie was watching us. I was so shocked by that when I found out Howie Carr was watching us.
That's awesome.
I've been watching Howie Carr for like 25 years. Like, you know what I mean? It's wild. But Howie's one of the good ones that, I wish there were more of him. Here's one. Andrea, being an appeal attorney, would you be interested in being appointed for the defense to fight an appeal?
Well, so I'd have to be pro hac vice, of course. I'm not licensed in Massachusetts. I would expect, they already have Mr. Weinberg. He's outstanding. He's an excellent attorney. So I expect they have already staffed their team with this type of option in mind. I'm such a huge fan of Robert Alessi. I am such a fan of this guy. Him. He's amazing. He's a really spectacular attorney, and I can just tell from how he argues and when I'm reading his pleadings and stuff like that, he is very much thinking with the possibility of an appeal in mind. Sometimes attorneys, you get caught up in the combat of the trial, and that's your main focus. But it is always helpful to be framing things in a way, or just be thinking about how you can attack a certain issue in a way maybe that's gonna give you the strongest footing on appeal. So I get the sense from just my read on what he files and stuff that he does have that kind of mind, and that's part of his process as well. So I'm not saying no. I'm just saying I don't know that they need me.
That's what Betterow said. He said, "Yeah, I don't know if they need me, but said the same thing. Never know. They might call."
Well, I'm here.
Here's another question. How about Bev not allowing Birchmore info to come in? What do you think about that?
Mhm.
That to me was kind of wild too.
Yeah, this one I'm a little more kind of on the fence on. I don't necessarily think this is the worst ruling. The issue I have with it is where it directly impacts the people that are testifying in this particular case and their credibility. So, for example, I personally very much believe Trooper Guarino should be able to be impeached with the 30 some thousand text messages that he overlooked in the Sandra Birchmore case, and are playing a significant role in him being federally prosecuted and for a death penalty case. Like, that's kind of a big deal. That's kind of significant. Other players that have some overlap here, like Fanning. Pretty sure Lank isn't Lank. Got one foot in both investigations. I can't remember now off the top of my head, but Guarino is the one that really stands out, just because it's a situation where it goes directly to his competency and his performance of the same task that he's been asked to do in this particular case, and how that then relates to, you happen to miss the Jen McCabe deleted Google search, how the Hoslong to die in cold type of situation. So that I think should be fair game, but just in and of itself, like kind of broadly, the fact that Canton PD did this investigation, cleared it of any wrongdoing, and they have been kind of overruled, so to speak, by the federal government. It is a little bit far afield. It does get you in the risk of having a trial within a trial, where now we're having a trial about the Sandra Birchmore investigation in order to impeach the Karen Reed investigation, and I'm not sure it's honestly in her interests anyway. It just ends up being a little bit confusing and hard to follow.
Good comment from Positive Vibes about Higgins. Maybe the defense could use this one. If it mattered that much about the whiskey, he would have asked before he went over. Exactly.
It's a good point.
Totally.
Very
Right?
good point. Yep. You got
If
any
that's all you
Jameson? How
drink,
hard is that?
I mean, I think with my stomach, I'd be like, "You got any chicken wings? You got any buffalo? What do you got over there? Like, got any food? Pizza? You got any
Mhm.
D&E pizza? I'm coming over."
No, 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 please, no.
Yeah. Yeah. Well, late night, I might eat it. I don't know. Not now, but Glamasu says, "Andrea, what do you think of the judges in Mass rotating between civil and
Mhm.
criminal cases?"
Mhm. I don't know. I don't really mind that. I like judges to be well-rounded. It's one of the common complaints I have when we get a new judge on the Court of Appeals. Often the judges that we get, because our Court of Appeals judges handle the entire caseload, you don't have them designated to certain case types. And there's a massive learning curve when you have a civil lawyer, somebody who spent their entire practice in like medical malpractice litigation or something like that. There's a massive learning curve to learn criminal law and procedure in the state of Washington. And we have a whole like independent constitutional jurisprudence. Like, we don't argue Fourth Amendment case law in Washington. We have all our own case law in Article 1, Section 7. Massive amount of stuff for like a new judge who knows nothing about criminal law and practice to learn. So I like in general this idea of judges having broad exposure to different case types and kind of getting that breadth of experience.
Great. Kelly Reed, cousin of Karen Reed, just made a comment. She said, Andrea, you are wonderful. I'm a huge fan." She says, "Mike, we're going to need another fundraiser for the First Circuit Appeal. Free Karen Reed." Wow. Yeah, I guess we may have to do some more fundraisers now.
Yeah, appeal to the federal circuit court will not be inexpensive. And the reality, honestly, like the thing that's so shocking about these types of process, it costs so much? Printing. They have still to this day these like arcane printing requirements that you have to, like, only certain specialized printers really know how to do it. You can't just like file your PDF in the the federal circuit court.
What does it have to be like a longer print, like of the paper? Like what is it? What is the real difference on
Well,
that?
so I don't know specifically about this circuit. The
Yep.
one that gets the most attention, of course, is the U.S. Supreme Court, and it's mainly just that they have certain typesetting requirements, certain font requirements, like all of these things that are so specific and precise that there are specialized printers that literally that's what they do. It has to be a certain number on certain like with certain colors of on the cover. For different types of brief for distribution to different people. It's like it's very specific and complicated. So because of that, there's like 2 or 3 printers in the US that are like the people that you go to if you need to file something in the US Supreme Court.
I know that you don't cover Aiden Carney case as much, but you're not afraid of it.
Mhm.
Um, one of the things that came up on that just drives me crazy is that I was watching him like a lot of people, and he's criticizing these police officers
Mhm.
from the Massachusetts State Police, and then they come and arrest him. The
Mhm.
same ones that investigated him. The state
Mhm.
said, "Oh, there's a conflict of interest, so we're gonna have a special prosecutor in your case because we can't have the DA doing this case because there's a conflict." But they let the same state police that he was criticizing investigate him. To
Mhm.
me, that is just, like, so wild. It's like
Yeah.
fascism. Like, you're basically you can tell these guys are mad.
Mhm.
Proctor, Tully, Buchanan, they're mad at him
Mhm.
because he made them look bad. Let's be
Mhm.
serious. And the state
Mhm.
police, this group of state police are now knocking at his door, talking to witnesses. They're doing all this stuff against him. I mean, have
Mhm.
you seen that before where the state police that are getting criticized by a journalist with his reporting are now on
Mhm.
the case to put him in jail, and they're the biggest witnesses against him? Some of them are saying they've been witness intimidated by him, which is
Mhm.
I mean, this is wild. What are your comments just in general about that and Aiden Carney, the case with the state police and the whole thing?
Yeah, well, fortunately, I don't personally live in a banana republic, so I haven't had that experience come across my desk an awful lot. But yeah, this should be raising major alarm bells with anybody because this is, I mean, kind of beyond red flags for abuse of process concerns here. The conflict of interest is just the most obvious one that's out there. How can you be the witness for something that you're investigating? Like those are completely independent roles. You're not impartial. You're not objective. You don't have any incentive to go and undermine your own story and look for the full picture of where the evidence leads. I mean, if nothing else, so the fact that that's even allowed is just a little bit shocking to me. Um, it's such an obvious point of attack for the defense that like why would you give them that ammunition anyway? I think your point is extremely valid. I haven't really. I just we've got limited attention and time and everything can only focus on so many cases and stuff and so I haven't followed his case particularly closely, but I did at one point in time, maybe a year or so ago. One of the search warrant affidavits I was able to get a hold of, and I read. I don't remember what it was for, um, but it was like it's like a 30-page affidavit, like 25-page affidavit. Tully had authored it, and I
Oh,
just remember being, so shocked at the attention and effort they had put into this investigation over Turtle Boy, I think, going to a football game and saying mean things to people at a football game. Then
lacrosse,
they,
yes. Yep,
yeah,
yep.
okay, look, my bad. Sorry about
Whatever,
that.
yeah,
Uh,
girls lacrosse.
then they put into the investigation into the death of John O'Keefe. Like it's just
Right.
such a remarkable contrast, and so that really does it really does, I think, tell you everything you need to know that when their own interests are at stake, they'll put in the work. Uh,
Like the Canton Police, they actually transcribed an interview I did. They did
mhm,
pages of an interview because I interviewed the duck guy who was
mhm.
They said did and they end up dropping charges against him. It's like they spent more
As they
time
should.
investigating my interview with that guy than they did with the, John O'Keefe case, which is just unbelievable. It's
Yeah.
wild what they
Well,
put
I
time
mean,
into.
it does. It speaks to the threat that this exposure is. As you know, I've talked on your channel before I box, and I think a
Yeah,
lot about courtroom stuff in a martial type of framework. And the time that your opponent is the most dangerous is when you've got
when
him
they're
stunned.
doing this. Yeah,
You've
when they're
landed
lunging
something hard,
forward.
and you've rung his bell, and he's having to back up onto the ropes. That's when you got to be your most careful. You want to put him down, but you can't be stupid and you can't be reckless because he knows he's about
Wounded.
to he's about to be lights out, and so he's going to bring absolutely everything he still has left to keep that from happening. And so it's the same type of situation, I think, that this exposure really threatens. That's why it's so telling how they're reacting the way that they are. It's that important to them, and that should tell you everything you need to know about why are they doing it. Because he's a threat, they have to try to neutralize him.
Awesome. I love that you box. How long have you been boxing for?
I'm in like year 10 now.
Wow.
Been a while.
Amazing.
Yeah, been a while. Technically, I don't have my thing
You
here,
have any
but
injuries? Have you ever gotten like your
no,
bell
doesn't
rung
my
or anything
nose
like
look good? I must be
that?
pretty good, huh?
Yeah.
No,
Have you had
actually, my joke, my kind of running joke is that I started boxing because I used to do a lot of long distance running, and I would get too many injuries long
injuries? Yes.
distance
Oh, I
running.
know.
So I
My uncle is a big long distance runner. He got the injuries. Totally.
Yeah, yeah,
Totally.
you get a lot of wear and tear stuff. So, boxing's a little bit different, but no, I've never, never had any kind of significant injury from it. It's
It's
great
great.
fun. I encourage anybody to give it a try. You don't have to spar, although it is fun. It really is. It's not that bad. You get pretty used to it pretty fast. Um, but that's the whole game. They say you spend about 6 months learning how to punch, and then the rest of your life learning how to not get punched.
It's the name of the game. Don't get punched.
Yep, hit and not get hit.
Yes. Don't get hit. Don't as my grandfather used to say, don't step in it. uh, there's a question from Terry. She said, not sure if covered, but hasn't Brennan made himself a witness? Phone data of Morrissey. Thoughts on Higgins rehab rumors? I don't know. Wait, has Brennan made himself a witness on the phone data of Morrissey?
Well, um, not so much in the case in chief that I can see. This would all be stuff that would be these would be legal based motions. These wouldn't be things that the jury would be hearing about and making decisions on Karen Reed's guilt or innocence because of like the potential for text messages between Judge Cannoni and Mr. Morrissey. If that happened, they would be moving to disqualify, and it would be something that the judge would decide. And if she was smart, of course, she'd recuse herself, let another judge decide it, and then, if necessary, go up to the appellate court. So he's not really a witness in that sense, where like he can't be the prosecutor because he might have to get on the stand and testify to the jury. It's kind of this gray area, middle ground, where when you're dealing with pretrial proceedings, they can be witnesses. I mean, we see the attorneys filing affidavits, for example. Affidavits are testimony that's making them witnesses to those things that they're including in their affidavits. It's just that because those aren't things that are going in front of the jury, they're for purposes of those preliminary rulings. That's generally considered to be okay. So that's how I think. That's where I think this would ultimately fall in that grand scheme of things. And I don't know about Higgins rehab rumors. You'll have to fill me in on that.
Yeah, there's been rumors. I don't want to talk about that because it's not
Okay.
unknown and it doesn't really.
Yeah. Yeah.
Who cares?
I
It's
mean,
just
in general, if people have an alcohol problem, I'm very much in favor of rehab and
exactly
recovery. So, that's
good
something
for
that
him. But
that we should
if
applaud and hope for.
exactly if he's getting rehab, good for him. That's what applaud it. You brought up well the Tara actually or Tara brought it up
Mhm.
about Brennan. What about Morrissey? Because we talked about this earlier.
Mm.
The cheesy banana email. How likely is he to be actually brought up as a witness because the DA wants. I mean, I keep saying the DA. The defense wants him as a witness. They want to cross him. They definitely want to bring him on
Mhm.
the stand about
Mhm.
this ex parte communication emails with a cheesy banana email, the burner email he was using. How
Mhm.
is the judge going to allow that? Is that going to ever happen? Any chance of it? Have you ever seen a DA brought up on the stand because he's sending off cheesy banana ex parte emails?
I think it's unlikely. It's another one of these situations where, yeah, it's misconduct from my perspective, but it's not directly connected to this case unless they've got him communicating with Judge Canoni about this case. And then if that happens, you got a much bigger problem than just whether he testifies or not, you know? Um, so the fact that the district attorney might be an unethical kind of guy, it's just not typically going to be admissible. He's not the one that's running the investigation. Certainly not at this point. He got, you know, they already got kind of the remedy for him being biased, which is that he personally can't handle it, but other people in his office still can. So I don't really see anything changing significantly from the last trial where, they wanted to do it there as well, and Judge Canoni didn't allow it. So I don't expect they're going to be allowed to this time, but I certainly do hope that when we have these hearings next week, I'd love for them to fill in some of the details about what exactly would you like to ask him? What is your reason and your purpose for getting him on the stand? Because it would be interesting to see if they've learned anything new since the last time they did this.
I would love to see those emails. What
Mhm.
like speak you brought that up. Next week there's
Mhm.
gonna be hearings. What do you expect to see next week? What are you looking for? What do you want to see? What are you hoping for?
Yeah, well, I mean, so the bulk of it is supposed to be these motions in limine, right? So we got these 30 motions, and a lot of them are really, not unfamiliar. Like we've heard a lot of them
Oh,
before. The Commonwealth wants to exclude third party culprit again. Defense wants to call, Morrissey and Mr. Nelson again. Um, that one actually I am kind of interested
Steve
in too. Not
Nelson?
not just Mr.
Yeah.
Morrissey, but also, yeah, Mr. Nelson, because he would have had a role during the first trial, right? He's the victim witness coordinator. It's part of his function is to be that go between and to communicate logistical types of things to the witnesses. But he has apparently seemed to be involved in a role that's a little bit more than Mr. Brennan certainly describes in his motion. It's just they're there to provide support and information and connect with resources and stuff. Well, yeah, but if you're attending
Okay.
interviews and
Yeah.
you're coordinate, involved in kind of coordinating all the information and stuff like that. That's a little bit outside the scope of what a victim witness coordinator usually does. So I am interested for sure in hearing if they have any new information about his role that could potentially influence whether he's kind of become a witness to this or not. A potential impeachment witness is what I would expect. Um,
So here's a witness that wasn't called. Well,
yeah,
was called last time that is not on the list this time. Officer Barros is not
yeah,
on the Commonwealth witness list this time.
yeah.
There's
Uh-huh.
also a tow truck driver that
Mhm.
we've seen audio from on Twitter, but they were
Mhm.
never called to the stand either. Do you think these witnesses the defense should call? Barros, Officer Barros, if the prosecution isn't going to bring him up this time, should the defense, and will they get to talk to him privately and kind of find out what he
Mhm.
really knows beforehand, and should they bring up the tow truck driver too?
Yeah, so Barros is a definitely, from my perspective, they already have him on record from the first trial. They know what he's going to say. They had his report, and his report was what undermined the timeline that Trooper Proctor was trying to establish the taking possession of Karen's car at 5:30. He's the one that says the taillight was cracked but not completely broken. Do they have the ability to talk to him privately? It's really up to him. And so normally police aren't really all that receptive to being unnecessarily cooperative with the defense. Like, sure, they'll attend a deposition, they have to, but the deposition, the other side gets to be there, so there's no kind of element of surprise that you might get if you're able to talk to a witness off the record and informally. So I would not expect normally that he would be inclined to do something like that. But you just never know. I mean, one of the things I kept pointing out is that very often the worst enemy of the bad cops is the good cops. And so, if he's a good cop, he could be outraged at what he's seen, and he could potentially be cooperative like that. So I wouldn't probably bet on it. Like, I wouldn't put the Vegas odds in his favor, but I wouldn't say, no, it can't happen and it isn't possible. But he is a little bit of a risk, of a wild card. Part of the limitation on his testimony that first time, we got that information. The taillight was cracked, but not completely broken. Well, we would love to have that spelled out, right? Like, okay, so here's the picture of it in the Sally port. Did it look like that? That's really what we want to know. Is that what it looked like when you saw it? But that's such a high risk question for both the defense and the Commonwealth to ask, that none of them are going to ask it. And so we don't know. We didn't get that information in the first trial. And unless somebody has found a way to get it behind the scenes, I don't expect we'll get it at the second trial either.
See, that's so frustrating. Like, I wish I could find out beforehand. True, though. That's such a good insight, because I think most police officers aren't going to want to talk to the defense. It just happens.
They just usually don't, and it's just, that is how it is.
This is a funny comment. Deja Vu Trial 2 says, could they compromise no Turtle Boy for no Morrissey? That's not how it works, right? I mean, that would be funny. We're going to make a deal. You don't bring up Turtle Boy, we won't bring up Morrissey. What do you think?
Yeah. Like, who's the bishop and who's the knight? Who's giving up who in this situation?
It's funny. I love our chat. We've had a lot of super chats. I tried to bring them all up, but there were some I didn't get up. I'm really sorry. I try to ask every question, but there's quite a few of them tonight. Andrea, I want to thank you so much for being here. It's been 2 hours and we're already, like, it went by like in 5 minutes. I feel like I left some questions out. There's so much. Is there anything else that you wanted to bring up tonight that we haven't discussed or touched on, especially related to Karen Read?
Oh boy. I mean, I feel like we've, covered as much as we realistically can in this type of time frame. There's been a lot of commentary already about all of these different motions in limine, so there's a lot of that already out there on different channels. Pretty sure Melanie's gone through them. Melanie Little.
She's phenomenal. You've been on her show recently. What was that like? That must have been fun.
I did. I finally got to meet Melanie in person, and that was fantastic. I've been waiting for that for a long time, so I really enjoyed it. Melanie, I find her very sharp, very astute, good lawyer.
I love watching her. She is so good at just going through, like you said, going through the documents. She's really good at it.
Yeah, and she's got such an eye for detail. She catches a lot of things that and I think, because she's the OG on this case. She has been on this case for so long, and she knows all of the ins and outs and everything of everything. And so she's often, got reads on stuff that I maybe haven't necessarily picked up on, because she's stewed in this for so much longer than I have. So yeah, I'm a huge Melanie fan.
I can remember when she did her first show on this. That was like when I was actually feeling the pressure from the DA's office, and I was freaking out. And then I saw her, and I was like, oh, I feel better now. I feel better. Yeah. Look at this woman. She is amazing. She was like, she is so good. It is.
Well, and there's power in numbers, and that's one of the things I loved about my chat when I was streaming this trial the first time, is that we have the power in all seeing things. I mean, not that we're like a group hive mind or anything like that, but like, we've watched this evidence for ourselves and are not going to be gaslit about what we've seen. And so we gave each other permission to believe our own eyes. And sometimes that's just a comforting position to be in. You know, people think that they're alone. They're the only one that sees things this way. Come to my chat, vet your opinion, vet your thoughts, and you might find out you're not alone.
I love our chats. I do.
Mm-hmm.
There's another question that came in. Andrea, have you seen the habeas rulings? We did talk about that.
Mm-hmm.
He said, Greg says it reads to me like her constitutional rights were denied, but there's nothing I can do about it. Is that my understanding of it correct? You haven't, I just got to make sure people know you haven't really had time to read it all over. I mean, we were live. I know you're scanning it now. So,
Yeah,
I mean,
it's a fairly short document. I don't necessarily read it that way. They're just saying that there were these 4 specific issues that were presented that raised a question of constitutional magnitude. The court is ruling against her on all of those, except for the 4th one that it really doesn't have to reach because it's not necessary given its rulings on the other ones. And so its ruling is just basically saying, has she made a substantial showing of the denial of a constitutional right? Does she have like a more than bare bones argument? You know, does she have a reasonable showing? I think we saw. Of course I didn't watch. You can't watch. There's a live stream of the argument on the habeas, but I did follow like the folks who were live tweeting what was being said and how the arguments were being presented, and it did seem pretty clear from that the judge did have some concerns about it. More though from the policy kind of standpoint, this shouldn't be the way it is. Like I'm being forced to ignore what these jurors are saying, you know, about their processes. I can't pay any attention to that at all. So less concern really with what does the law actually require, although, you know, again, there was some much more favorable case law for Karen in that situation than there was, from my perspective, at the state level. So I think this is essentially saying he doesn't think her constitutional rights have been violated, but she's got a good argument that they are. And so because of that, it's not like this isn't a completely frivolous one that we can just, you know, throw out and not have to dig in. It warrants the people at the higher pay grade taking a look at this and giving their own opinion.
We had one more question. They wanted to know if
EDB is awesome.
Yes. This other question I had, they wanted to know if you did watch what I call the hostage video, the Michael Morrissey. Did you watch that video when he
You
put
know,
out the
I
statement?
did. I haven't watched it in a long time though. Like I watched it a while ago.
Yeah,
But
me
yeah,
too.
I've seen it. I've seen it,
Yeah,
and
I
I mean, yes, it is. It's
yeah,
troubling, and there's a reason why even Judge Cannoni had to say, "Yeah, this crossed the line into into unprofessional." It did.
right. Even
It
she noted
absolutely
it.
did.
It's funny how a lawyer, just went over it, and I think he was totally shocked by it.
Mm,
It's wild to see people picking that up now, like
mhm.
for the first time, and realizing that, like, how crazy this really has been for so long
Yeah,
here.
yeah, yeah. It really has, and just the efforts that they have gone to try to put their thumb on the scale. I mean, again, it's just the hostage video and the whole press strategy, the, you know, going to the content creators and all that. But like you pointed out too, the witness intimidation charges against the people who have spoken up. Um, you know, I really can. I can understand. I've said before, I think it might have been on Melanie's channel. I definitely have some ambivalence about just the whole idea of courthouse protesting, you know, and protesting like legal processes. And my view is that um protest is it's best suited for a situation where you have folks that are making policy level types of decisions, right? And so they're trying to decide, is this the rule we should have for everybody? Is this not the rule that we should have for everybody? When it comes to like, what are the facts and how have the rules been applied here? It's not a situation where you really want political pressure to influence that type of decision. So I'm very like sensitive to people think an injustice is being done. They want to be heard, you know, and I get that, and I definitely think that's very important. But that's why I have a little bit of ambivalence about that situation. Having said that, though, um, prosecuting people for leaving rubber ducks, for
Yeah,
leaving little rubber ducks,
I got
like
one from the main villain, the guy who this is from he gave this is what he gave me during the interview. It got
I love
cited in
it.
his, like, arrest, his indictment. I keep it with me to
I
remind
mean,
myself, like, that this was like a felony for him.
yeah.
Unbelievable.
This is so far over the top. It's so far it's such an overreach from even if you know they also have well I mean they're clearly more than ambivalent about about the attention that this case has gotten and the feelings and perspectives that people have about it. But just to overreach so far into something like that, it's just it really is. It's scary. It's scary.
It
Like
is.
I feel sort of nervous for folks in Massachusetts. Like you live there, you live under this type of framework. Maybe I'm naive about where I live, but people aren't getting arrested for rubber ducks in
Oh,
my
I know.
my
It's gotten
neighborhood.
crazy here. I mean, number 1, the law and witness intimidation is wild because they could basically
Yeah,
arrest you for anything if you make someone upset.
yeah,
And you know what killed me is that at one point they were going to people's homes who were like grandmothers for
hmm
doing things like putting messages online or even, God forbid,
hmm
leaving a voicemail for somebody. Like,
hmm
they really and the whole thing is they were g like, they went drove from Canton to Gloucester, which is south of the city to north of the city. For us, like, it may only be 40 miles, but it's 2 hours each way, full of
hmm
traffic, and it's like to investigate what? Just, basically to basically try to get these people to say, "Turtle Boy and Karen Reed put me up to it," and nobody
yeah,
said it because it wasn't true, like,
because it wasn't
they were
true.
basically trying to instigate case against Aiden and Karen and tie them together, and it fell apart because it was no
hmm
truth to it, and everyone was like, "F you," like,
hmm
eh, so, I mean, to me, it's wild, some of the stuff that we've seen. And
hmm
I'm sorry to throw the F you. I try to not be a little better than that, but it just drives me crazy. Some of the
No,
stuff
it
that they've
does.
done to people who are grandmothers. There was a woman that we still talk to. She's a big supporter. She,
hmm
uh, she and the coming on, she was in recovery.
hmm
And they were making hints at her. Bukaki was really intimidating her and making comments about her recovery, just
hmm
because she wasn't going along with what he wanted her to do. And it
Yeah.
just to me, some of the most disgusting behavior that they harass people who aren't even me. Like when they
hmm
came after me and harassed me, that freaked me out. But the average person without even having any followers, not having any
hmm
support, not having lawyers. I have tons
hmm
of access to support from lawyers in the community. A lot of these people didn't. So to
Yeah.
me, that was like some of the worst stuff that they did. It's really frustrating to see it.
Well, and I think that was part of the whole point, right? Is that if they can keep people isolated, people think that they're alone. People they're the only ones fighting it and stuff. It's just they're much easier to control when you know that you have a whole groundswell of other people who are seeing this the way that you do, who see that this is a massive injustice. I mean, this is the benefit, of course, of the whole the free Karen Read movement and the protests and things like that have been so visible. Is that those people that maybe are isolated and maybe not even on social media or just marginally on social media, not necessarily well connected and stuff like that, they see they're not alone, and that's exactly what somebody who is trying to control the narrative is going to be afraid of, and that's what they're going to try to interfere with and prevent that from happening.
Glad James made this comment because I don't know if it was only women, but I would say almost every single one of them that I talked to was a
hmm
woman. They went
hmm
after women. They really have focused on going after the women. It was really disgusting what I saw.
hmm
So I'm so thankful that you came on tonight, Andrea Burkhart. Your attorney, where can
Mhm.
people find out more information about you if they want maybe legal advice, if they're looking for legal advice, or just to follow you on YouTube, Twitter, and your Substack as well?
Yeah, I'd say best thing is just follow me. You can send me message requests on Instagram or Substack if you're inclined to do that. I don't have a super active practice at this point. Most of my practice has been in public defense anyway, so I haven't had a big private caseload for quite a number of years now. But I am always happy to kind of talk people through where they might look for help for their issues or something like that if something comes up. So yeah, feel free to shoot me a message on any of those platforms, and I'll be happy to do what I can.
Awesome. And I know some of I've been watching the comments tonight. A lot of supporters here. They're telling me that you just got back from vacation. Is that true?
I did. I did. I spent 2 months down in Chile, down in
Oh,
yeah, the southern part of the globe, mostly in Patagonia, but I went down and I'm a big hiker. I love to do, treks and things like that. So kind of one of the highlights of this trip was a 5 day trek that I did on Navarino Island, which is way south. It's like almost Antarctica. At one point on the trek, you can look across. Oh, we're way past the Beagle Channel now. You're looking at Cape Horn, out at the
wow.
graveyard of the Pacific and stuff. So it's just a really magnificent, wild, once in a lifetime type of experience, and I had a great time.
Christine F is saying she loves your pictures. You must see them
Oh,
on
thank you.
Instagram. Yes.
Yes.
Awesome. Well, thank you so much. I'm glad you had fun on your trip and you're back. And we're very excited to have you back for the Karen Reed trial too. Looking forward to it. We have it pinned in the chat. Your YouTube right now. We had the Substack pinned earlier. I hope everyone watching go follow Andrea if you're not already. I know most of you already are. How many subs do you have on YouTube right now? You have a lot.
I'm at like
No,
113, I think.
113. Wow. Did
Yeah,
you get the plaque? Did you get the or did you
I
not
did.
order it? You
Yeah,
did.
I did get the plaque. I don't have it displayed or anything, but yeah, I did.
Oh, that's awesome. Oh, well, I thank you so much for being here tonight, and hope you come back because everyone loved you tonight, and we're really happy to have you covering Karen Reed or 2.0. And thank you for being here tonight, Andrea Burkhart.
Yeah, absolutely. Pleasure anytime. Let's do it again for sure.
Awesome. Thank you so much, Andrea. Have a great night.
Thank you. You too.
Where the Young Jerks, she was amazing. I'm so happy that she came on tonight. That went perfect, except for my one mute. I had one mistake tonight. And I'm very self-conscious about the hair now because of Jimmy last night. I don't know if you saw the imitation. Oh my God. And then I muted myself. That was so much fun tonight with Andrea. If you're not following her, please follow her. That was so much fun. Having a fun time tonight. Muting myself. I'm my hair. I'm very self-conscious because of Jimmy last night. He got me good. The imitation. I definitely need a haircut. Look at this hair. It just gets in my eyes now, so it's getting worse. But I had so much fun with Andrea Burkhart. I want to thank Attorney Burkhart for being here tonight. She's great. Definitely follow her on YouTube, on Twitter, on her Substack. We got another show I'm doing tomorrow night with a private investigator, Lauren. Make sure you check that out at 6 p.m. If you haven't followed us, please make sure you subscribe and get all the notifications and come back here, especially tomorrow night at 6 p.m. We'll have another live show. And again, if you're not following Andrea, you got to make sure you're subscribing and following her. You saw her tonight. If this is your first time seeing her, there's a reason why you should be following her. I am so happy that she's covering 2.0. One of our super chats tonight noted that they wanted to see her with Carl Steinbeck together. Carl Steinbeck. That would be a good show. Andrea and Carl would be phenomenal. I agree 100%. That would be a good show. Maybe we'll have to see if we can do that in the future too. Uh I'm just reading your comments. You'll be there. Thank you, Sam. You'll be there by 6 p.m. Excellent. Thank you so much. And thank you, Glenn Lake, for being here. I love our chat. Thank you, all our chatters tonight. We had a lot of people watching. Thank you for being here. Thank you for following. Thank you for last night. Last night was I'm on a high. Even though I got roasted. I wasn't prepared to get roasted last night. It was all for a good cause. To see all that, you guys just stepped up. There was some big contribution. A lot of several $500 contributions. Like that just blew me away. Mrs. Parks, another woman that I was communicating with today, she's getting stickers. I just thank you so much for last night. That was like one of the best responses to see that amount of money come in and to see how much you guys enjoyed all the guests last night and how much fun we all had. Even Brian, we put Brian. I felt a little bad. We put Brian on the spot a little bit. I didn't. I'd say it's more like the ladies did. But it was fun. I think Brian had fun too. It was a fun night. That was and you know what? The best thing about it is we all want the same thing. We wanted to raise as much money as we could last night, and we did it. We did a great show last night. So if you didn't get a chance to watch it, there was some competition. Go back and check that out. And if you haven't made your donation and you still want one of these stickers, we still got stickers left. I still got some of these. I got the Young Jelly. I got the Young Jerks. We could still do it. You could still make a contribution to Karen Reed or Aiden Carney, even tonight. Send me an email, mjcboston1 at yahoo.com, and I'll send you out some stickers. I sent out, I don't know, like 40 envelopes today and probably a bunch yesterday. I've been sending out a lot. I had to get a new box of envelopes. I went through the first box, 125. I got another box of 100. We're working on that one. I got some new stamps. I got some new stickers. We had to order some new stickers, but we're loaded. We got plenty of materials now. So if you want one, hit me up, mjcboston1 at yahoo.com. Send a donation, at least $5 or more to either Karen Reed Defense Fund or the Aiden Carney Defense Fund. And you know why we need the money? They need the money, not me. I'm not getting the money. They're getting the money. The defense teams are getting the money. The reason why they need the money is for those witnesses that we talked about, the dozen plus witnesses that Karen Reed has. She has to pay for their hotels. She has to pay for their airfare. She has to pay for their food, their Ubers. She has to pay for everything to have them stay here and get ready to testify. Same thing with her attorneys. Even though her attorneys are pro bono, they're not charging her by the hour. They still need to live here. They need to eat. You know what the cost of just a hotel in Boston is? It's out of whack. Like even rich people can't afford a night in a Boston hotel. It's wild here in terms of the cost of the hotels. And then you talk about what Andrea said, just the paper, just the amount of printing paper, supplies. So they both need the money. So if you can donate, and again, I know a lot of people can't donate. They don't have the resources. I've been there in the past myself. Believe me, I understand. I don't want you to contribute if you can't afford it. Just being here, just watching and supporting us, that makes a difference. It helps us get to the people who have the donations, who have the money, just by you watching. So, anyone that's watching this right now, you're a part of this. And I just want to thank you all. Yeah, what is the hotel cost in Boston right now? I'd say it's like $500 a night. Like, I'm sure you could probably still find one that's like, 150, 200. But I mean, it's a flea bag. You're talking, yeah, Boston hotels. We also have a migrant crisis too. Like a lot of the migrants were staying at the hotels. So there's always been a lack of hotels here. I mean, even back in the day before COVID hit, I used to host events where people would fly in around the country to stay here. And we were always looking for cheap hotels, and they just do not exist. And it's gotten worse. Like the last few years, the prices on hotels, yeah, gotten crazy. So good luck. Yeah, someone said $700 a night. That seems reasonable. With Karen and team, and her team are staying is approximately $700 a night. That makes sense. You know, very expensive plus fees. Yeah, Holiday Inn Express for AJ. I mean, even there, even if you go the cheaper route, you're still paying probably 350. Like that's Boston is crazy. We just don't have, yeah. Even if you stay at a Motel 6, it's crazy the amount of money it costs now. I remember back in the day when, you could get a hotel room for $50 a night. That doesn't exist. No way. No way. Yeah, it's like that everywhere. That's why almost everything's high end because, geez, if you're paying $300 for the cheap version, why not just pay 400 or 500 and get the nicer one, right? All right, I'm gonna head out and I'll see you tomorrow night. I got a great guest again, private detective tomorrow, 6 p.m. Please be here. I hope I got all your super chats. I didn't even check the Venmos. Last night, I was like I said, I was so blown away by Jimmy imitating me. When he did the hair flip, I almost died. I like literally, and then I started flipping when he was flipping. I couldn't do it anymore. It was just, and then there was all kinds of stuff going on that show last night. It was just so wild. And then to see all the money come in, all the donations and contributions, I got overwhelmed. I was just like, and I had to go to the bathroom and I had to go walk a dog. So I'm just like, I need to go. I didn't get to thank and even post all the donations and thank everyone like I wanted to. So I'm kind of sorry about that last night. I hope people aren't upset at me. I really love and appreciate everyone who supported and donated last night. It was amazing. It was overwhelming. I really almost couldn't handle it for once. You left me speechless. Jimmy did too. I didn't know what to do. For once on my show, I didn't know what to do last night. So that was wild, but it's a wild in a good way. I'm really thankful for you all. Sherry D said yellow young jelly sticker. She loves her young jerk stickers. Andrea and Carl show she wants that. Maybe we'll try to make that happen. Mike and Mods will make it happen. Sherry D, I think you know how to reach me. Just hit me up and tell us what sticker you want and just send along your mailing address again so I don't forget. We do have plenty of these. I can hit you up with some more. Definitely. I know you've made contributions. I really appreciate you. So if you want one, just hit me up. Send me an email. I'm gonna check Venmo real quick. Oh, Brian from LTL is doing a show tonight. He made a super chat tonight. We're gonna redirect everyone after this is over, as soon as this is over, to LTL tonight. So definitely go check them out and let them know we're making a raid over there. I want to thank Barbara for sending $10 on Venmo the other night. I didn't get to thank her. Thank you so much, Barb. Barbara, now I'm hiccuping. Get some coffee here. Hold on. All right, I think we're good. I think we're good on the Venmo and Cash Apps. So thank you so much to all the super chats, all the people watching. And again, I'll see you tomorrow night. We got a private detective here. She's been on Court TV a bunch. She was just on Brian LTL's show. It's going to be the first time coming on my show. I'm looking forward to that tomorrow night, 6 p.m. There's also Canton Select Board is heating up. There was a debate this week. You can watch it on Canton Community Television. Probably going to go over that this weekend, maybe either Saturday night or Sunday, depending. So check in on that. There's a lot happening there as well. Looking forward to covering it all. I'm very thankful. I'm very thankful for all the people who support and watch us, all the friends we've made. We'll see you tomorrow night, 6 p.m. And again, go check out Brian LTL. We're going to redirect you over there. Let him know. Young Jerks Raid. Have a great night, everyone. We'll see you over in the Brian LTL chat. And again, thank you so much to all our guests last night, Nurse Kim, Auntie Deb, Brian from LTL, Kelly Reed. Who am I missing? Boozy Beauty. They were amazing last night. I just love our guests last night. I thank our moderators, and I also especially thank Andrea Burkhart, attorney Andrea Burkhart, tonight. If you're not following her, make sure you're following her. YouTube, Twitter, and Substack. Have a great night, everyone. Thank you so much. Good night.